in Mr. Nash's current state. I believe he is one of the highest threats to community safety I've seen in my career. I think the only option for bond would be a high cash bond that ensures Mr. Nash is not allowed back into the community.
We're now on the record in two cases, 26 CR 583 and also 26 CR 586, People versus Mark Nash. Mr. Nash does appear in custody. He's represented by Ms. Parham, and Mr. Zentner is appearing for the people. How would you like to proceed, Ms. Parham?
And we are in receipt of the complaint information for each of Mr. Nash's cases. We would waive advisement in each case and request a preliminary hearing in each case, but waive the 35 days. And then we would just be asking to set Mr. Nash over to July 30th at 8:30.
Thank you, Your Honor. No objection to the waiving of the 35 days, noting the right to a preliminary hearing. No objection to the next court date suggested.
Okay, thanks. All right, I do find that Mr. Nash's right to a preliminary hearing in each case has been reserved. The parties have waived the 35-day rule with regard to each case as well. The cases will both return then on July 30th at 8:30, please. Thanks. You're welcome. We're on the record in two cases, 26 CR 583 and 26 CR 586, People versus Mark Nash. Mr. Nash does appear in custody. You can be seated, Mr. Nash. Thanks.
Let it be known to the court, I'm here by special appearance, not general appearance. I'm a living,
All
breathing
right, Mr.
person.
Nash, thank you.
Not
Ms.
corporate
Parham is
entity,
here
not
representing you, and then Mr. Zentner is appearing for the people.
conflict of interest here already, so.
Thank you, Your Honor. Mr.
Mr.
Fisher is also here.
Oh, okay. Oh, thanks. How would you like to proceed, Ms. Parham?
I was going to be asking to address bond this morning.
Let's see, from the prosecution.
Thank you, Your Honor. Ms. Parham did notify us of that. We are compliant with the Victim Rights Act. I in turn told her I'd be asking for a modification upwards or urging the court to do that. Thank you.
Okay, thanks. You can go ahead then, Ms. Parham. Thanks.
We would ask the court to grant a cash or surety bond in this case. The current bond is set at $1 million cash. That is not even in the realm of possibility for Mr. Nash to be able to post. Mr. Nash does have an apartment here with his wife. He's been in the same apartment for several years. He's a 10-year resident in Grand Junction, 8 years at the same address. He has no failures to appear in the last 5 years. He does have means to get to court, transportation, a cell phone to get court text reminders. Mr. Nash, while these are very serious allegations, they are allegations at this point, and the least restrictive conditions of bond should be imposed. And so we would ask the court for a cash or surety bond in each case.
Mr. Zentner.
Thank you, Your Honor. Your Honor, I wanted the court to just be aware of that People versus Rodriguez Nunez case, relatively recent case, 26 COA 48.
Yeah, I'm aware of it. Thanks.
Thank you, Your Honor.
Sure.
In terms of the unattainability argument that Ms. Parham just briefly referenced, we do want the court to set a bond or maintain this bond or even set it at $2 million, just based on our community safety concerns here. Your Honor, I don't know, I don't think this court did not handle the original advisement hearing in front of Judge Rahm. I did want to, in terms of complying with the Victim Rights Act, read a statement that was provided to the court at the advisement, and I want this court to hear it. Zach McCullough is an investigator, a detective with the Grand Junction Police Department, and he's our point of contact on the 586 case in terms of the VRA. According to Mr. Detective McCullough, he had been in law enforcement for about 14 years and have been involved in the investigation of many serious felony offenses. I'm also the detective that wrote the arrest affidavit for Mr. Nash related to this incident. I know the court has read the affidavit, so I do not need to get into the exact details of the case. Mr. Nash was involved in 2 separate violent criminal episodes between June 22nd and June 24th of this year. He also has a lengthy criminal history of the same type of behavior. Mr. Nash was given numerous opportunities for the situation to end peacefully, but instead chose to threaten law enforcement and ultimately shoot at police officers as they attempted to lawfully arrest him. This is not merely resistance. It was a brazen, violent assault on those sworn to protect the public. Mr. Nash's actions demonstrated profound defiance of the law and extreme disregard for the value of human life. In Mr. Nash's current state, I believe he is one of the highest threats to community safety I've seen in my career. I think the only option for bond would be a high cash bond that ensures Mr. Nash is not allowed back into the community. Respectfully, Detective Zachary McCullough. And then briefly, Your Honor, in terms of the allegations, the court's familiar with the affidavits from that detail the actions of June 22nd and June 24th. In the 586 case, Judge, if convicted of those counts, Mr. Nash faces a minimum sentence of 20 years to 64 years in the Department of Corrections as a crime of violence, Your Honor. And that's based on the statutory language with respect to when 2 or more crimes of violence or convictions enter, those sentences must be run consecutively on at least 2 of those. So that comes to 20 to 64 years. One of the bond factors, Judge, Ms. Parham didn't get into too many of those today, but one of the bond factors in 16-4103 cites the possibility or probability of intimidation of witnesses. I have no doubt that Mr. Nash will intimidate any witness involved in either of these cases. Community safety and appearance at future court are concerns, mostly community safety. He does have the 9 prior failures to appear, Your Honor, but his criminal history suggests that, as Detective McCullough referenced in his letter, Mr. Nash's criminal history includes numerous prior felonies, almost 24 misdemeanors. He's likely habitual eligible. The nature of the convictions in his past are violent, assaultive, threatening, and dangerous. And those are words that are titles of convictions he's had. So he presents a clear and present danger to the community, does Mr. Nash. I would ask the court in the 586 case to seriously consider a $2 million bond based on all of those individualized factual findings that go to protect our community. Bonds currently set, I believe, at $25,000 cash only in the 583 case, Judge. I'd ask for $100,000 cash only there. In terms of the victim in that case, we weren't able to reach him with respect to this particular bond argument, but early on he expressed concerns based on the proximity to Mr. Nash if he's released. Remember, he's the victim and the neighbor who was just trying to do a good thing and investigate some screaming and yelling downstairs and was assaulted by Mr. Nash. Thank you.
All right, thank you, Ms. Parham.
Mr. Nash indicated that he would like to make a statement against the advice of counsel.
Okay. So, Mr. Nash, you understand that you have the right not to say anything and that anything you say can be used against you?
Yes, I do, Your Honor. Like
Okay,
I said,
so why do you want to say something then?
I don't want to be known to the court. I'm here on special appearance, not general appearance. I'm a living, breathing person, not a corporate entity in all caps. I'm here on special appearance to challenge subject matter jurisdiction and personal jurisdiction because in case numbers 26-CR-586 and 26-CR-583, I demand to see a verified criminal complaint of the injured parties in these cases. I demand to know who the injured parties are in these cases, and I'd like to see an affidavit filed by the injured parties in these cases. Because as it stands right now, in order for me to commit a crime, it has to be against another living, breathing person, male or female. And in this case, I'd like all charges dismissed because I haven't committed a crime against no one. All these allegations are way out of line. I was in my Second Amendment right to defend myself in my home. and my constitutional rights. I was violating my Fourth Amendment right by never being properly served by Grand Junction Police Department or the Mesa County Sheriff's Department as I was booked in jail here for my arrest warrant. I have still yet to be seen, shown, or properly served an arrest warrant in this case, in case number 2C6CR583. And then in 26CR586, these allegations, when I was charged, I was already in the Mesa County Detention Facility at the time. So it's kind of hard to make how to make up crimes when I was already locked up. And then two, till this day, me and my wife Tiffany have yet been shown, seen, or properly served a search warrant for our property, home, vehicles, weapons, any property they took as evidence by the Grand Junction Police Department, which is another violation of our Fourth Amendment constitutional right. So like I said again, I demand a verified criminal complaint against the injured parties in these cases. I'd like to know who the injured parties are in these cases. And I'd like to know if there's an affidavit filed by the injured parties in these cases. Because like I said, again, let me know in the court, I'm here on special appearance, not general appearance. I made it perfectly clear in my arraignment.
Yeah, you've said that a number of times. I don't know what legal effect you think that has, but in my opinion, it has no effect whatsoever. So
Common law. Like I
that's
said.
why you're here in jail, is because I have jurisdiction and authority to have
Well,
you
like I
there.
said,
So
I have yet to see a verified criminal complaint, and I have yet to commit a crime against anybody, a person, living, breathing, or all you're saying is I've committed these crimes, but against a living, breathing person, I'd like all charges dismissed. And like I
yeah,
said,
you've said that
since
already.
the violation of my Fourth Amendment right under the
You've said
Constitution.
that as well.
I've
So,
never been served an arrest warrant.
all right,
Still to
Mr.
this
Nash,
day.
I don't think we're getting anywhere. I understand your position, and it's not, it's contrary to Colorado law. So,
Well, whatever, on this case, she told me she was basically gonna go get evidence, watch body cams of evidence to see that I never pointed, threatened,
okay.
or anything to it, and all she came back with was like, you mean, didn't break it into my window. And like I said, I tried for 2 hours to have the police officers come show me the arrest warrant, do my people, so I could give myself up immediately, and then they started threatening my life. So,
Okay. So those are things that if you go to trial or you contest things, you can assert that you acted in self-defense, and the prosecution has to prove beyond a reasonable doubt that you did not act in self-defense. But those are just things for more of a
Still to
trial
this day,
setting
I
and
still
things you
haven't been served
should
an arrest
continue to talk with your lawyer
I've
about.
not committed a crime against nobody. Not
Yeah,
living,
I
breathing
know
person at
that's
all.
how I know that's what you're saying, Mr. Nash, and that,
The state of
you're
Colorado
presumed to
can't
be-
charge me as crimes.
well, you're presumed to be innocent. So,
Like I said, well, then I don't understand how I was basically here to fix my car, okay? Fix my car,
Yeah.
and basically I was moving the hell out of Colorado. I even have, a place to go up in South Dakota and everything. And
Okay.
I'm being held on some allegations that make no sense, that I couldn't have possibly done, and she has proof that I
Okay.
didn't do them, so.
well, that's something that she'll,
I'd like a court date within 30 days, just another 30 days, because I don't have time to sit for 90 days or whatever. I mean, like I said, I had other plans. I didn't commit these heinous crimes. I didn't have the intent to commit these heinous crimes, and I didn't want to commit these heinous crimes. And in fact, like I said, I was incarcerated in this jail when the cases or the charges came up. So I don't even know how I made the crimes possible when I was incarcerated for 2 days. And like I
okay.
said, so
Yeah, and those are things that I don't know, Mr. Nash, but your lawyer can help you with all of those things.
right now, I've got a conflict of interest with the public defender's office because I fired the last lawyer they tried giving me. The lawyer before that didn't work for me. And I said, she don't even know what I'm talking about when this stuff comes up. And when she told me she was just gonna bring it, we waived our preliminary hearing for 30 days for her to get video evidence
Okay.
that I didn't do any of these threats. And now we're in here for a bond hearing that, like I said, I
Yeah,
can make any possible bond. but
It
like I
takes her a
said,
while to get things, Mr. Nash, and to review those things, and
Thank you, Your Honor.
oh, you're welcome. When would you like to come back to court, Ms. Parham, and for what purpose? I'll issue a written order with regard to bond. I need to look at the files and consider your arguments, so.
Could we have Mr. Nash come back just for a return August 25th?
No objection, Judge.
August 25th at 8:30 then? I'll
Thank
see you back then. Thanks.
Thank you, Your Honor.
You're welcome, sir.